Imagine, you're in the hospital, too ill or hurt to speak for yourself. Do you know who would make your healthcare decisions for you? There seems to be a bit of confusion around who can make healthcare decisions for us when we are not capable of making them for ourselves. We hope this video can help you understand how healthcare decisions are made in Ontario and by whom. To put it into context, in Ontario, before giving you any treatment, healthcare providers must get your permission. This is called informed consent. Healthcare providers must give you all of the information needed so you can make an informed decision about your treatment or care. It is important to note that healthcare providers do not make the decisions for us. The only exception of when informed consent is not needed is in an emergency. So who do healthcare providers get consent from? Ideally, it comes from you as the patient. After all, it is about your healthcare. However, there may be a time when you are not mentally capable of making your own decisions. In this case, the healthcare provider will turn to your substitute decision maker, or for short, your SDM. This is the person or people who are legally authorized to make your healthcare decisions for you if you are not mentally capable of making them yourself. Every person in Ontario has an SDM because the law has given us all one. There is an automatic ranking list called the Hierarchy of Substitute Decision Makers and is outlined in the Healthcare Consent Act. So who is on this list? Before we go through it, there are a couple of things to note. It is in ranking order, which means healthcare providers by law must speak with your highest ranking SDM. Also, if there are multiple people on any of the levels, they are all equally ranking SDMs and must agree on the decisions together, or must decide amongst themselves which of them will act as your SDM. Now, let's look at the hierarchy. As you can see, it is grouped into three categories: legally appointed SDMs, automatic family member SDMs, and SDM of last resort. Starting at the top of this list, the highest ranking SDM is a guardian of the person. This is someone who is appointed by the court to be your SDM. This is a relatively rare circumstance. The most common legally appointed SDM is the attorney named in a power of attorney for personal care. This is the person or people you have chosen to be your SDM in your power of attorney for personal care document. Attorney in this case does not mean lawyer. Attorney means the person you have chosen to be your SDM. For more information about power of attorney, visit the Ministry of the Attorney General's website for Ontario-specific resources, or visit your lawyer. The third type of legally appointed SDM is a representative appointed by the Ontario Consent and Capacity Board. This is another application, but this time to a tribunal. For more details on becoming a representative, please visit the CCB's website. If the legal steps noted above have not been taken, you still have an SDM for healthcare. The following family members are your automatic SDMs. The highest ranking family member SDM is your spouse or partner. Spouse or partner can be same-sex or opposite sex and means you are married to each other or are in a common law relationship, meaning you must be living together for at least 1 year, are the parents of a child together, or have a cohabitation agreement. Two people can be deemed partners if they have lived together for at least 1 year and have a close personal relationship that is of primary importance in both people's lives. The next level is parents or children. This level includes all adult children and your parents. If children are in the care of Children's Aid Society, it is the Children's Aid Society that is the SDM for the children. Level 6 is if a parent only has visiting access to their children, he or she falls at this level. Level 7 is all your brothers and sisters. Level 8 is any other relative, and this is by blood, marriage, or adoption. If no person in your life meets the requirement to be an SDM, then the Office of the Public Guardian and Trustee, a government-appointed representative, is the SDM of last resort. The public guardian and trustee will also act as your SDM if there is conflict among equally ranking SDMs who all want to act but cannot agree on the decisions about your treatment. The public guardian and trustee does not choose between the disagreeing SDMs, but is actually required to make your healthcare decisions for you. In order for someone to act as an SDM, they must be highest ranking on the list and meet all of the following criteria. They themselves must be capable. They must be at least 16 years old. There cannot be a court order or separation agreement prohibiting access to the incapable person. They must be available. Healthcare providers must be able to get a hold of them in the time frame needed. And finally, they must be willing to assume the responsibility of being an SDM. Nobody can be forced to act as a substitute decision maker. If your highest ranking SDM does not meet the requirements, the healthcare provider will then turn to the next person on the list. So now what? We encourage you to think about who you want to make your healthcare decisions in case one day you are not able to make your own. Is this person the highest ranking on the list? If yes, you do not have any legal paperwork to fill out. They will be your SDM automatically. If they are not, you may want to consider completing a power of attorney for personal care. Remember, while you don't need to have a lawyer prepare your power of attorney, they will be able to answer any questions you have and provide you with advice about your specific situation, so it may be a good idea to speak with a lawyer. So, when should you decide who will make your healthcare decisions for you if you can't make them for yourself? Now! It's always too soon until it's too late. For more information about healthcare consent, advanced care planning, and substitute decision making, please visit the following websites.